event will offer news, insight, and values for all of us. Subsequently, I declare the International Seminar on Challenges of Reforming Indonesia Criminal Law is officially open. Thank you.
Thank you very much. Would you please to remain on stage? Mohon tetap di tempat, Bapak. We will continue with the photo sessions. We kindly invite the Vice Dean for the Finance and Human Resources Affair, and also all the coordinator programs, invited speakers and moderator. Thank you very much. Excellencies, ladies and gentlemen, that was the opening ceremony for the International Seminar, Challenges in Reforming Indonesian Criminal Law. Now, please allow me to introduce the speaker and also moderator for the seminar, because we will start our seminar for today. And we warmly welcome the moderator for this seminar, Mr. Nyoman Satya Yuda Dananjaya, SH, MKN, PhD. This is an honor for me to introduce him as a moderator for this seminar, because Mr. Dananjaya has just returned to the faculty after completing his doctoral degree in Japan. He was graduated from Udayana University for his bachelor degree. Then he continued his Master of Notary degree at Gajah Mada University. And just like I mentioned before, he finished his PhD doctoral degree at the Yamaguchi University, Japan. Is that correct, Mr. Dananjaya? Okay, so we kindly invite to the moderator and also all the speakers that join us here in the aula to move over and sit at the place. And Professor, I also invite you to join this seminar session. Okay, I see the wrong camera. Okay, so Mr. Dananjaya, the floor is yours. Para pembicara, kami undang untuk menempati tempat yang telah disediakan. The floor is yours, sir.
So good morning, ladies and gentlemen. I'm really excited when the committee invited me as moderator for today's seminar. My name is Yuda. Thank you for the chance given to me. So today's seminar topic is Challenges in Reforming Indonesian Criminal Law. So if we talk about Indonesian criminal law, it is always related with issues on the draft bill of Indonesian Criminal Code. So ladies and gentlemen, today's speaker will elaborate their opinion, their ideas, and of course their thought and intellection on how Indonesia should face the challenges to reform Indonesian criminal law. So ladies and gentlemen, in online and offline hybrid seminar, it is now my pleasure to introduce our speaker. So the first speaker is Professor Tim Lindsay AO. So Professor, can you hear my voice?
Yes, I can.
Thank you. So Professor Tim Lindsay is a professor in law in Melbourne Law School, Melbourne University, Australia. He is one of Australia's leading experts on Indonesian law, and and has advised government, business, international organization, court, and legal practitioner in Indonesia and Australia. He is Malcolm Smith Professor of Asian Law, Redmond Berry Distinguished Professor and Director of the Center for Indonesian Law, Islam and Society at Melbourne Law School, Melbourne University, Australia. So he holds a Bachelor of Laws, Bachelor of Art, Bachelor of Letters from the University of Melbourne, and completed his PhD thesis in Indonesian Studies. He has won National and University Teaching Award and was an ARC Federation Fellow from 2006 to 2011. Professor Tim Lindsay is a member of the Victorian Bar and was the long-serving chair of the Australia-Indonesia Institute until 2016. Professor Tim Lindsay is a specialist in a wide range of aspects of Indonesian law, including public law, criminal law, commercial law, and family law. He also teaches and researches Sharia law or Islamic law in Indonesia and Southeast Asia. So he expressed his ideas and thought about law in Indonesia and Southeast Asia in various articles in international journals, as well as in the form of book chapters, whose various articles have been cited more than 4,000 times. And he also wrote books about Indonesian law, both in English and Indonesian. So ladies and gentlemen, give a big applause to Professor Tim Lindsay A.O. So our second speakers are Dr. Ibu Dagus Surya Dharmajaya and Mrs. Igusti Agung Ayu Dika Widyastuti, Master in Law. So Dr. Ida Bagus Surya Dharmajaya, born in Denpasar on June the 5th, 1962, and currently as head of the Department of Criminal Law, Faculty of Law of Udayana University. He holds a bachelor degree from Brawijaya University in 1986, Master of Law from Indonesian University in 1992, and completed his doctor in law thesis in 2012 in Brawijaya University, Malang City. He wrote many articles in various aspects in criminal law, especially criminology, victimology, narcotics crime, anti-corruption, the witness and victim protection, and also terrorism. He also active in making research projects within the scope of criminal law, and his 4 latest research projects are compensation as a treatment for victims of violent criminal act in criminal justice system, compensation implementation and asset recovery, restorative justice in Indonesian criminal justice system, and the last one is protection to the traditional community values in criminal law reform. Give a big applause to Dr. Ida Bagus Surya Dharmajaya. And Dr. Ida Bagus Surya Dharmajaya will accompany with Mrs. Igusti Agung Ayu Dika Widyastuti, born in Denpasar on July the 14th, 1980. She holds a Bachelor of Law from Udayana University in 2003 and Master of Law from Diponegoro University in 2013. And she's currently as a student of doctorate program in law, Faculty of Law of Udayana University. She wrote many articles in various aspects of criminal law, especially cyber terrorism, discrimination against women's inheritance right, anti-corruption, the witness and victim protection, and publishing a book on corruption prevention education through the street law method. She also active in making research projects within the scope of criminal law, and her 3 latest research projects are awareness in developing anti-corruption behavior, the relevance between social media and criminal rate, and the extent of customary crime arrangement in customary regulation at the Elder Village, Panglipuran. So ladies and gentlemen, give applause to Mrs. Igusti Agung Ayu Dika Widyastuti. So I will continue to introduce our third speaker. So our third speaker is Mr. Lucas Banu, born in Singaraja at 13th of March 1979. He holds Bachelor of Law and Master of Law from Udayana University. Mr. Lucas Banu is a lawyer who has strong background in law with focus on business law, contract law, and company law. He is a founder of Helping Hand Bali Foundation in partnership with Direct Management Services Limited in New Zealand. From 2012, as lawyer at Law Office Lucas Banu and Partner, and from 2017 as the chairman at Institute of Justice Law. He's also the director of Tuayan Raya Sejahtera Limited, and he also a legal consultant of APCF the USA and a legal partner of Brazilian Embassy for Indonesia, and from 2021 as a head of legal aid institution of Advokasi Peduli Bangsa KAI Bali Chapter. So ladies and gentlemen, give applause to Bapak Mr. Lucas Bayu. So our fourth speaker is Mr. Bagus Hermanto, born in Denpasar City on 14th of June 1997, hold Bachelor of Law from Udayana University, and currently as a student of Master Program in Law, Faculty of Law of Udayana University. He has a lot of organization experiences both inside and outside university, and the latest are member of the education sector for Generasi Baru Bank Indonesia atau GDLN, and national level cadres and ambassador of Parade Cinta Tanah Air, the Ministry of Defense, the Republic of Indonesia. Mr. Bagus Hermanto also awarded as 10th best student of Udayana University in 2018 and appointed as part of national delegation for internationalization and strengthening Japan-Indonesia in Yamaguchi University and Nagoya University for short course and academic exchange in 2018. So ladies and gentlemen, give applause to Mr. Bagus Hermanto. So ladies and gentlemen, before I commence, I would like to inform you that today's seminar will be divided into two sessions. So the first session is presentation sessions, and it will take 1 hour for this session, and each presenter or each speaker will have 15 minutes to deliver their presentations. And then after the last speaker finishes their presentations, and we will continue with the Q&A session. So ladies and gentlemen, let's begin the seminar with the presentation session. So I will invite Professor Tim Lindsay to deliver your material entitled Indonesian Criminal Law Challenges for Reform. Ladies and gentlemen, please join me in welcoming Professor Tim Lindsay, AO. Kindly proceed.
Thank you very much for that very generous welcome. Let me first begin by thanking Udayana Faculty of Law for inviting me to speak today. It is a pleasure to be in Bali, even if it is only virtually. I wish I could be with you in Bali, and I look forward to joining you all in the future once the pandemic is over. I have to say, like many Australians, I miss Bali at the moment. And I know when I come back to Indonesia, I will like to visit my friends at Udayana, all of you again, and see what the opportunities are for collaboration. Let me also just thank my former student, Dr. Igusti Ngurah Parikeset, or Sigit, for inviting me to join you today. I'm very grateful to you, Sigit. So today I've been asked to talk about Indian criminal law challenges for reform. Just excuse me for one moment while I share my screen with you. Thank you. Can you see my slideshow? Okay. Crime and punishment in Indonesia is another way of putting the topic. The drafting and enforcement of criminal law is a result of a complex interaction between the state, society, and individuals. Criminal law is a way of articulating and applying normative ideas about what a community should be like. And this means criminal law usually has deep political implications. It is therefore no surprise that as Indonesia transited from a colonial regime to a liberal democracy, to a dictatorship, and then again to a democracy, that criminal justice and sometimes criminal injustice has played a prominent part in key political events, and also that politics has always played a prominent part in criminal law. The current problems facing Indonesia's criminal law system are therefore largely political, and they are a result of a long trajectory that Dan Lev traced to the collapse of parliamentary democracy in the late 1950s. This is true, but it has antecedents in the ideological debates of the nationalist leaders in the years leading up to the Declaration of Independence in 1945. The debates then about the form the new republic would take, the contest between advocates of a liberal democratic republic and proponents of authoritarianism, or in Indonesian political thought, integralism. Eventually, a democratic model was agreed upon, but the job of drafting the constitution was given to the leading proponent of integralism, Professor Supomo. Integralism takes what history has shown to be the naive view that state and society are identical and unified, and there is no need for checks and balances, because the state, embodied in the ruler, will always have the interests of the people at heart. This, of course, has been shown by history to be wrong. Predictably, the constitution Supomo originally produced established a very powerful presidency and gave limited powers to all the other organs of states, and it gave no rights to citizens. This set a model for criminal justice that empowered the state and the presidency and made the courts essentially just an arm of the executive and paid little attention to rights. This model doesn't apply under the current constitution, but it has proved to be persistent and influential in Indonesian legal culture ever since, including in criminal justice. And that is true, even though Indonesia soon adopted liberal democratic constitutions, first a federal liberal democratic in 1949 and then a unitary state in 1950. In fact, the 7 years after 1950 were a unique period of relative integrity for Indonesia's criminal justice system. From 1950 to 1957, there was a high sense of professionalism among lawyers and judges, reflecting the large Charter of Human Rights, the separation of power, and judicial independence that these two constitutions, unlike the 1945 Constitution, guaranteed. Now, that liberal democratic system, as we all know, began to unravel in 1957 when President Sukarno declared as form of emergency rule, suspending most state institutions, and then in 1959 when he abolished the liberal democratic constitution and reintroduced the integralist constitution in 1945 that allowed him to rule directly. The promulgation of what he called revolutionary law and the power he claimed to intervene in court processes and overrule court decisions led to a rapid deterioration of professionalism across the legal sector and the politicization of the criminal process. The result was, as Lev says, harsh laws, unfair trials, incompetent prosecutions, judicial errors, and unfair sentences. When Suharto toppled Sukarno, taking power in 1966, his promises to restore legality and negara hukum were welcome, but quickly proved to be an illusion. Instead, Suharto continued and in many respects extended the authoritarian rule of his predecessor. He was helped by a military bureaucracy that quickly took control of government and the legal systems, making the courts a tool of the ruling elite. Despite swinging Indonesia from the political left to the far right, the Orde Baru retained Supomo's integralist model developed under Sukarno, with all the problems that this created for criminal justice, as I've just described. But now, those problems were complicated by a new problem as corruption became widespread, institutionalized. Corruption certainly took political influence, for example, so-called telephone justice, but an elaborate system of institutionalized and state-approved bribery also emerged, and that famously stretched under Suharto from police stations to prosecutor's office to the steps of courts where Chalo waited with their clipboards in hand to collect and distribute payments. It stretched to judges' chambers and to the presidential palace at that time, which received a cut of most legal payments to state officials. In time, this huge and highly organised system of corruption became the only way that defendants could deal easily with criminal charges. After Suharto fell in 1998, amid political and economic chaos, delivered by the financial collapse when the rupiah floated in 1997. The 1945 Constitution was comprehensively revised, as we all know, to swing the political pendulum back again, this time towards liberal democracy. The amended 1945 Constitution that was finalised in 2002 would have been almost unrecognisable to Professor Supomo. It had expanded from 71 to 199 articles, so that almost 90% of the Constitution was new or amended. The Constitution now is much more similar to the Liberal Democratic Constitution of 1950 than Supomo's document. And it contains now a lengthy Charter of Rights, separation of powers, for the first time a constitutional court, guarantees of fair elections, and provisions that push the military out of politics and back into the barracks. Judicial independence is also guaranteed, and the Supreme Court was taken out from under the control of the Menteri Kehakiman and given independent authority over Indonesia's courts. These changes were dramatic and far-reaching, and they led to a creation of a new, much more open society and a far more democratic political system. However, sadly, these important reforms have not resolved the deep problems the criminal justice system inherited from the first two presidencies of Sukarno and Suharto. In particular, the lack of professionalism and traditions of institutionalized collusion between law enforcers and judges continue. Some critics will say that the courts in Indonesia have gone from non-independence to independence but without accountability, and are resistant to efforts to introduce oversight. It is true that political interference has decreased, but there is no evidence that the entrenched system of bribery developed under the new order has also decreased. In fact, convictions of judges for judicial corruption confirm that that system of corruption is still alive. As the United Nations Special Rapporteur on the Independence of Judges and Lawyers, who visited Indonesia in 2002, said, quote, "Allegations of widespread corruption are real. Yes, there are some honest judges, but the integrity of those judges is tainted by widespread judicial corruption around them in the courts in general." Today, more than 2 decades since Suharto resigned, Indonesia's criminal justice system seems to be under pressure close to breaking point. To be sure, there are certainly courageous lawyers, private lawyers, NGO lawyers, and government lawyers who are committed to justice and the rule of law, but the task they face is overwhelming. Because very little of the complex machinery of criminal law enforcement works the way it should, it is difficult for an honest lawyer to succeed. To begin with, the legislative foundations of criminal justice are left over from previous eras. The Colonial Criminal Code of 1918 and the Orde Baru Criminal Procedure Code of 1981. And in fact, even the progressive aspects of both the KUHP and KUHAP are often ignored in practice. Both statutes are flawed and outdated documents that urgently need reform, but the bills to replace them are also problematic. Efforts over many years to patch up the problems in KUHP and KUHAP by passing other laws has led to a forest of lex specialis, many of them overlapping and contradicting one another. These special purpose statutes include aspirational human rights laws that have It is still true that the institutions entrusted with the enforcement of these laws, police, prosecutors, and judges, again, although there are some honest and brave members of those three professions, that these institutions rarely function as they should. The courts are sometimes showpieces for resistance to reform rather than the forum that ensures reforms are implemented. Three of the most serious problems in the court are the lack of weight given to the presumption of innocence, the general weakness of judicial reasoning in many criminal judgments, and severe inconsistency in sentencing. It is true that, as argued above, most of these problems have been inherited from the Sukarno and Suharto eras and from the colonial regime. But many of these problems have become worse over the last 15 years. There are many reasons for this, including President Susilo Bambang Yudhoyono's reluctance to take firm action to support reform during his second term, and the limited interest that President Joko Widodo has in legal issues and his limited enthusiasm for law reform and human rights, both of which became clear in his first term. However, part of the explanation must also include the growing social conservatism and in particular the religious intolerance among Indonesia's Muslim majority. This is often manipulated for political gain by politicians, usually at the disadvantage of vulnerable people such as minority religions, Indonesia's unorthodox religious groups, LGBT individuals, and of course women as well. The use of Islamic norms in perda to achieve these ends by creating new moral offences are most often supported by secular politicians with an eye to elections rather than to scriptures, and they have been increasingly problematic since around 2005. This is especially true of Aceh, the only province in Indonesia with the legal right to apply Sharia, where the rights of women and minority groups are increasingly under pressure. All these factors, combined with the war on drugs and politicians' entrenched enthusiasm for criminalisation as a preferred policy response to the many issues that come before the legislature, all these things have now led to extreme levels of prison overcrowding. This has created truly horrific conditions for the more than 250,000 Indonesians now in jail. And this neglect also extends the use of the death penalty, which has become a tool for political benefit. The complex criminal law in this area has sometimes been ignored by the courts, with tragic consequences, including for mentally ill and underage prisoners who have faced execution, in breach of provisions of KUHP. The result is that Indonesia has a criminal justice system that is in deep trouble. For the state, it is not a reliable instrument of policy, an effective way to control society and individuals, because it is subject to corruption and resistance. For the same reason, it offers society little protection from corrupt individuals who, if they have the money and political means, can easily subvert criminal justice. On the other hand, ordinary people who lack political and financial means, who are not politicians and not wealthy, find the system offers them little or no defence against the powerful should they decide to mobilise criminal justice against them. In late 2015, Indonesia's criminal justice system once again became the subject of major national political controversy, as it has many times. With the newly elected DPR due to be sworn in on 1st of October, the outgoing Anggota DPR had flagged their determination to pass a new criminal code. The draft code included many highly controversial provisions, including some that would make it an offence to criticise the court, others that would make it an offence to criticise the president, which was a provision that had already been struck out by the Constitutional Court in 2006. Other provisions would criminalise most forms of extramarital sex and would other problematic provisions as well. And so there was no public consensus in support of the draft bill. These and many other provisions were contested publicly by a wide range of interest groups, including on different sides, conservative Muslim groups and progressive civil society activists. In fact, fear that the draft KUHP would become law sparked the largest demonstrations in Indonesia since the fall of Suharto. thousands of students and members of civil society marched in Indonesia under the banner Reformasi di Korupsi. And their protests, their objections to the draft code were accompanied by protests against the law amending the law on the KPK. Protesters saw the law amending the KPK law as a defensive measure by the government to destroy the highly regarded KPK, to prevent it from conducting the fearless investigations of corruption among the political and business elite, which the KPK was famous. The protests soon became violent, with people being killed and nearly 300 hospitalized on one night in Jakarta alone. Police arrested thousands of students, many of them without charge, many denied access to lawyers. Under pressure from President Jokowi, the outgoing DPR agreed to leave the decision on the criminal code to incoming members. But Jokowi did not accept demonstrators' calls to repeal the KPK law. And now it appears that, as the protesters feared in 2019, the KPK is being rendered toothless and ineffective by its many enemies in the government and the DPR. This is one of the most concerning developments in criminal law in Indonesia. And the world is watching. To conclude my presentation today, the draft criminal code is still a subject of intense public debate. There can be little doubt that if politicians move to pass the KUHP, it will again generate huge public opposition because there is still no social consensus in support of it. The many problems in the national criminal justice system and its deeply political nature means that any changes to any part of it, for better or worse, have a direct impact on many Indonesians, whether rich or poor, and have huge implications for how the Indonesian state and society operates. A new KUHP would affect every social group in Indonesia, but in very different ways. Take, for example, students. Their interests are diverse. Some are concerned to cater to religiously intolerant identity politics, but others seek political legitimacy by opposing those identity politics. Most of them, however, are unified by a fear of increased transparency because corruption is so ingrained in Indonesian politics, and it ties politicians to corrupt business and the judicial mafia. That is their difference. The public may be divided over many issues, including a deep split over morally conservative or Islamizing regulations. But most members of the public generally want to see greater transparency and more accountability, more tanggungjawab from the elite that rule them. And they would especially like to see lawmakers and law enforcers under greater control. That means that there are big differences between the interests of politicians and the interests of the public. And these divergent interests mean that national agreement or consensus about the kind of criminal justice reform Indonesia urgently needs will remain very difficult. It also means that even if positive reforms are passed into law, it will be very difficult for them to be fully and fairly implemented by law enforcers. Maybe only one thing is sure: the road ahead to criminal justice is not a straight road, and it is not a smooth one. That concludes my presentation today, and terima kasih.
Thank you for your valuable presentation, Professor. So even we know that in Australia currently is facing a big storm, but your commitment will give my appreciation. So thank you for delivering your very good presentation, Professor. So now we will move to the second speakers. So I will invite Dr. Ida Bagus Surya Darmojaya and Mrs. Igusti Agung Ayudika Widyastuti to deliver their presentations entitled Sentencing in RUU KUHP Harmonization Effort Between Fair and Legal Certainty. So to Dr. Ida Bagus Surya Darmojaya and Mrs. Igusti Agung Ayudika Widyastuti, kindly proceed.
for to the moderator for the time. First of all, I say very much thank you to the committee to give our department to present the presentation in the seminar. The presentation comes for our collaboration in the Department of Criminal Law, Faculty of Law, Udayana University, represented by me, Surya Dharma Jaya, and Igusti Agung Ayudiko Widyastuti. Ladies and gentlemen, the audience, our title of representation is sentencing in RUU KUHP, harmonization effort between fairness and legal certainty. The presentation about sentencing system in Indonesia and try to reform for the criminal law in the future. The background of our presentation is most of us is already know that the sentencing priority is as an effort to criminal countermeasures today. We can see from the imprisonment is the prima donna in sentencing. Consider its perspective as the most appropriate punishment for the criminal to actualize justice and an effort to social defense. The big problem in our criminal law process today is the high sentencing disparity due to the immensity of judges' independence to discretion. The wide discretion trigger a sentence distinction among the perpetrators who commit the same kind and quality of crime. Our criminal law reform committee tried to enter some thing to resolve the problem with regular sentencing purposes and guidelines that unknown in the KUHP as children. Our positive criminal law now, in sentencing system, we just focus on criminal act and culpability. That's the committee trying to solve the problem. The problem concept in our presentation is whether RUU KUHP sentencing purposes able to actualize the legal certainty and fairness. The second, whether sentencing guidelines will reduce judges' independence in sentencing. And the last problem we analyze is whether by arranging the sentence and guidelines purposes guideline will promote ideal sentencing. To analyze the problem, we put some doctrine, criminal law, sentencing theories, consideration in sentencing, and criminal law policy and criminal law reform. The philosophy of sentencing based on retributive and deterrence theories. In retributive theories, the purpose of sentencing is to revenge only, no other purposes. Deterrence theory. In deterrence theory, the goal of sentencing is to social defense and the perpetrator, like put up fear to committing crime, make the perpetrators incapable of committing crimes, put up fear for the perpetrator to committing crime, and resocialization and rehabilitation. The concept of consideration in sentencing is principle of proportionality and efficiency. The law enforcement officer must pay attention to the seriousness of the committing act, the perpetrator background when committing the crime, and the successful of sentencing. The three things must be have intensive from the law enforcement official. Criminal law policy and criminal law reform. Criminal law policy, as usual, consists penal, non-penal, and changes the community perspective about crime and punishment, according to Hofnagel's. Our Indonesian criminal law policy to perform a criminal law reform. The criminal law reform constitutes to reform the criminal substance, to streamline the criminal law enforcement in the future, then crime prevention becomes better. We push on provide more spaces for rehabilitation the perpetrators and minimize the reduction of the perpetrators' rights in sentencing. To achieve the goal of criminal law reform, we use two approaches: policy approach and values approach. Criminal law reform performed in policy approach with evaluate studies, observe the global agreement, comparative studies, and observe the scientific orientation development of the criminal law. The value approach the national values, the European values, and the international values such as a convention, declaration, etc. Now the sentencing purpose in RUU KUHP, we can see in Article 51. Yeah. One, to prevent the criminal act committing by enforcing the laws to protect the society and social events. The second, to socialize the conflict by conducting treatment and education to become a better and proper person. The third, resolving conflict caused by the criminal act, the need recovery, bring a peaceful and safety to the community, and the last, the fourth, refocus and release the conflict guilty feeling. And the sentencing guideline regarding the community perpetrator and victim concern, the law enforcement must pay attention to the X problem in the community. Yeah. The crime committed with planned or unplanned, how to commit the crime, law and justice values with life in the community. And for the perpetrator, pay attention to perpetrator, the form of perpetrator guilt, motive and crime purposes, perpetrator guilty mind, perpetrator attitude and behavior after committing a criminal act, perpetrator biography, a social and economic condition when committed crime, punishment influence the perpetrator future tense. And to the victim, criminal act influence the victim and their family, and a pardon from the victim and their family to the perpetrator. The problem in sentencing purposes of RUU KUHP, first, there is a contradiction between correctional and public safety purposes. Public safety drives the concept to isolate at the prison to the criminal, including imposing a death penalty on them. Otherwise, correctional and to encourage the convict to have a better and worthwhile life by socializing them to the community. The second, there is a denial to the fairness values when the repentant no longer has a purpose in sentencing, encompassing those who are guilty punished with an appropriate sentence to the act and mistake. It also a denial of the function of criminal law where the written law is applied to the less feasible act in traditional community. Sentencing guideline and the judge's independence and RUU KUHP. This is the inter-sentencing guideline. Maybe will give a problem for the law enforcement officer in making sentence. In the criminal justice system, judges standing to investigate and examine a criminal act and perpetrator's criminal responsibility. Furthermore, judges' position for punishing the perpetrators. The principle of judges' independence to constitute an autonomy of the judiciary to make an objective and impartial decision. In determining cases, the judges have the freedom to filing the applicable law and understanding the living values in the community. The judge also free from all form of the influence. But like in the front, to big discretion for the judge, something, or maybe high disparity in our sentencing system. Yeah. That's the committee will try to enter the sentencing guideline in RUU KUHP, not mean to arbitrarily restrict the judiciary independence. Precisely give a guide to the judge before deciding so as the decision will be proportional and efficient. That is the positive aspect. There are some notes for adjustment the sentencing purposes and guideline in RUU KUHP and fulfill legal purposes. In the future, judge must notice that the determination of sentencing purposes and guideline and RUU KUHP are constituting a philosophy of fairness and legal certainty. And following the guideline will produce a decision that satisfies these two aspects, fairness and legal certainty. As an effort to fulfill the fairness, the sentencing purposes as stated in RUU KUHP must notice the following conditions: the community understanding of fairness, protecting society from crime and criminal act, protecting society from the perpetrator. Our conclusion: imposing a proportional punishment to the perpetrator will bring a common sense of fairness. The successful sentencing will prevent criminality, resolve conflict, and limits recovery. By sentencing will actualize protection to the community. Successful sentencing will cause the perpetrators incapable of committing crime. Resocialization and rehabilitation are the way to eliminate the perpetrators with mind and repentance for their deeds and realize their mistakes. This correction will actualize the protection to the community. In sentencing, judges notice our objective of sentencing purpose that stated and consider the most priorities objective and customized to the case. We have to pay attention to the integrated punishment and the conditional condition. In sentencing, judges notice the applicable rules in the sentencing guideline, so sentencing will be more efficient, which means legal purposes will be actualized with legal certainty and fairness for the society, perpetrators, and victims. Thank you.
Thank you for your insight, Dr. Ida Bagus Surya Dharmajaya. So now we will continue to the third speaker, Mr. Lucas Bandung. So I will invite Mr. Lucas to deliver your presentation entitled Law Enforcement in Globalization to the Legal Investment of Investment Activity. To Mr. Lucas Bandung, kindly proceed. Check.
First of all, I would like to thank you for the invitation that given to me from the Dean of the Faculty of Law. I'm very appreciate and I feel that I'm privileged to be here. And thank you for all the lecturers and also the attendance. And I would like to thank you also for Ibu Supasti. She is my favorite lecturer in Udayana University. In the beginning, I'm not too interested in the business law, but she inspired me a lot. That's why I'll be here. I'll be a lawyer. Thank you, Ibu. And I still remember how you encouraged me to take the capital market as my subject in the first test, and then I continue in the Magister of Law, and I do the comparison of law between the common law, New Zealand and Indonesia. Thank you for that. Thank you for the moderator also. I just remind him to stop me if I speak a lot.
Yes, of course.
Yes,
Yeah.
because if I talk and I sing, I forget to stop. So the title that I want to deliver this morning is about law enforcement in globalization era to the legal investment of investment activity. As the practical, I think I don't have to explain more details about the history and also the theory about the criminal law, and it's already delivered very details by the professional team and also from Pak Ida Bagus. And this time I just want to focus to the practically in the investment. So first of all, I want to make a declarations. Every time I do the presentations, I always to tell about this. The first one, in some ways, I still lack in several things. That's why I encourage all the attendants to verify and do the confirmations about what I deliver, so we can testify everything, is it true or not. So please to do that. Then for the future, I need the input and the suggestion, advice from anyone in order to improvement in the future. And the last one is nobody will fake. Yeah. Always I remind this, and why we need to teaching one each other, supporting one each other, and I believe this is for our goodness in the future. I think for the background we can skip and then we go to the next slide. Oh yeah, background. Before I explain stuff about the investment, I would like to explain more details about the terminology of the globalizations, because it has become popular at the end of 20th century, right? It's related with the international process of culture, social, politics, and economy, right? I want to show you the picture of Thomas. Next, click. Next, yeah. Again, next, yeah. This is Thomas Eriksson. Thomas Eriksson mentioned that there are three main drivers in economic aspect. Number one is the dismantling of trade barriers, so no more barriers to do the business. The second one, the rise of emerging economies, and the third, technological innovations. And this brings the implications to the globalization to create the economy integrations and also the conical to the one society. That's why we hear right now there's an issue or maybe like an agenda to make one currency and then to be one system in the future. The next, there are some groups agree with the globalizations and also not agree with that. One of the group that's not agree with the globalizations is Susan George. She is focused to the fight against in the third world and development country. She is a political scientist. We can check in the Google about her biography. She brings the three fundamentals idea that implemented by the pro-globalizations to boost their agenda. Number one is a free trade of goods and services. Like I said before, no more borders, and everything can be delivered. Border of the country is no more. And number two is capital circulations freely. And number three is the freedom of investment. I will start to number three, freedom of investment. So the questions to consider is how about the Indonesia? Where is the position of Indonesia? What is the perspective of Indonesia to the freedom of investment? And we need to understand about the comment of Undang-Undang Dasar 1945. In the fourth paragraph, it's mentioned to promote the general welfare, and number two, to enrich the life of nation. So two main purpose in the pembukaan Undang-Undang Dasar 45, we can conclude that Indonesia is the country or the state who hold the principles of the welfare state. So personally, I want to say that it doesn't matter freedom investment can be done in Indonesia or not, but as long the implication of the freedom investments bring the general welfare and also enrich the life of the nations, then Indonesia should support that. So the focus of Indonesia government is not in the issue of investment, but how the impact of investment could support the realization of welfare state in Indonesia. If you want to talk about the investment, there are two items. It can be done direct and not direct or indirect. If indirect, we know that the foreigners can invest through the capital market. but I'm not saying, I don't want to discuss about the capital market at the moment. I want to discuss or explain about the direct investment through the PMA establishment. We know there's regulations that cover this activity is Act number 25, 2007 on capital investment. Undang-Undang nomor 25 tahun 2007 tentang penanaman modal. And we need to understand also about the process of ownership the land in Indonesia. Why? Because if the foreigners want to do investment in Indonesia, then they have to think in the future, how about my living? Then there's a possibility for foreigners to own the land or the property in Indonesia, and we'll discuss more detail about this in the next slide. In the PMA establishment, we know that the minimum capital required to set up the PMA is 10 billion rupiah. And we have to make a notification in here, it's only for one KBLI, one sector of the business. So for example, if the foreigners want to do investment in restaurant, and then they want to do other business like gym or spa or something like that, they have to provide to 20 billion. So 10 billion only for one KBLI. That's why every time if the foreigners want to do investment, if they come to us and then get the advice, we always remind them, sure, 10 billion only for one sector of the business. And the KBLI, Klasifikasi Basuh Lapangan Indonesia, has a plenty classification. We have at least 700 something pages. Yeah. And the second one, we have to understand also about the list of investment negative. We call DNI, Daftar Negatif Investasi. So there are businesses that close for the foreigners, but there are businesses open for the foreigners as an investor. And also there's a policy about the percentage of ownership. Can be 51-49, can be 70, and we have to understand also about where the investment come from, because Indonesia has a network, for example, in the Southeast Asia nations at ASEAN. Indonesia governments apply different for the investor who come from these countries to the investor who come from different of ASEAN. Number 3, I want to make a notification in here about the bureaucracy to do the investment in Indonesia. Before we apply PPZ, but now we have a system, OSS, it is online single submissions. So this is the challenge for all of us, not only for the foreigners, but also for the advisor, anyone who pointed by the investor to arrange the PMA establishment for them. So notice there are potentials of criminal cases in the company establishment. Why? Because the regulations already mentioned in the Article 64 of the KPM, regulations number 6, 2018. Anyone cannot provide false information and false data, so must be real. And number 2, in the Article 6 of BKPM regulation number 6 to 2018 mentions anyone cannot make a share ownership agreements for and on behalf of other people. So no excuse for nominee agreement. I said again, no excuse for nominee agreement. Why? Because the legal investment in company required And some of them think that the cost is too expensive. That's why the foreigners prefer to deal with the local partner in Indonesia and arrange the nominee agreement. Number two, it's not easy for investors to find the Indonesian business partner in Indonesia who meet the criteria. I mean, for example, if I'm an investor from out of Indonesia and I want to do business in Indonesia and the regulations require the local partner in share ownership, for example 49, the questions to me, where I can find that person, where I can find Indonesian as a local partner who have a same vision with me to running the business. If I can find that persons, then the next questions, are they able to provide or to put some money, same with me? Because this require 10 billion. It's not easy. This is number two. And number three, it's too long process and cost a lot for PMA establishment. We can check, come to the lawyer or notary. But Ibu, please tell me how much I have to spend if I want to set up the PMA company. They come, okay, at least 70, 80 billion, a million, under 100 million, and it's not included with the permits, like the EMD, and other permits, domicile, and etc. So I have an experience before. One of my clients from Australia said to me, Lucas, your country is the country with the long and complicated bureaucracy. But I said, yeah, this is in my Indonesia. If you want to do investment, yeah, you have to follow the process. But if not, you can do investment in another country. But together we have to think how we can support. The next is land ownership. I want to explain about the potential benefit for government of land ownership by the foreigners in on-tax payment. The foreigners can own the property in Indonesia based on hak pakai, right to use. And it's already mentioned in the Agrarian Minister Regulations number 29, 2016. But this is limited. Why? Because the period of ownership only 25 years, and foreigners can extend another 20 and then 25. So the total maximum is 75 years. And they have to pay the tax buy and sell. As we know, if there's a transaction from the buyer and the owner, the buyer need to pay 5% and the owner have to pay 2.5%. Normally, we have three different prices. The first one, NGOP. The second one, dispenda. Number three is market price. Normally, dispenda is in the medium. So they will apply medium. But if the foreigners want to buy the property in Indonesia, they have to make minimum 5 billion rupiah. We can see in the attachment of that regulation for Bali. Maybe different area have a different price. So it doesn't matter if the foreigners want to buy at the corner of Karangasem Regency, maybe at the mountain, top of the mountain.
I'm sorry to interrupt you, but you still have 3 minutes time.
Yes. Thank you.
3 minutes.
Thank you.
Thank you.
And it doesn't matter the size of the land, maybe 100 square meters, and maybe the price only 50 or 100 juta rupiah. But the tax calculations must be counted in 5 billion minimum. So The foreigners prefer to pay lowest cost, lower tax. That's why they prefer to do the nominee. And then the next reasons, foreigners get the wrong advice for nominee agreements. We know that nominee agreement is illegal, but some of us, I'm not saying the institutions, but I say the actor, that actor, advise to the foreigners, investor, oh, but Mr. or Miss, it's okay. We can set up a nominee agreement. It's safe for you. So this is the challenge also for us. I have experience before. One of my clients from Australia just got deported. Why? Because he did the nominee agreement in here. Wrong information. Why? Because she got the wrong information from actor. I'm not saying the institutions is like a tax department, but actor in here. So it's need the commitment and also capacity for all of us to fight the nominee agreement. The last slide for me. The law influence on the legal embezzlement of investment activity. So in these presentations, I would like to recommend the clear regulations that rule violations of nominee agreement. It must be done properly. And we need the synergy of related institutions to do the monitoring for legal embezzlement of investment activities through the immigration, tax department, police, prosecutors, the court. So not only the actor, but we have to think about Junto 55, Junto 55, turut serta bersama-sama is nominee, must be punished as well. And the last one, we need to increase the legal certainty for anyone who involved in the legal embezzlement. I believe that if all parties together they commit to fight against this embezzlement, and we will save a lot for the income of this country. As we know, many years ago, the governments applied the tax amnesty, and the government get a lot of income from that program. But next, the income, the potential income for the country, this government, is from the tax payment. That's why everyone needs to commit and also support this program. I think it's enough. Thank you for the time. I deliver back to the moderator. Thank you.
Thank you for your presentation regarding crime in investment sector, Bapak Lukas Banu. So now we'll move to the last speaker, Mr. Bagus Hermanto, who will deliver their presentation entitled Discover Future Prospect of Indonesian Criminal Law Reform. So to Mr. Bagus Hermanto, kindly proceed.
Thank you, Bapak Lukas. Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom and Namo Buddhaya. I hope all of you will be pleased because today we have a great chance because today it is a great time for us to learn about our future, about criminal justice system, and also about the future of how to reform Indonesia criminal law. First of all, I would like to express my gratitude because today we have special event that I believe that it would be fruitful and enlightening our insight, especially when we talk about our nation legal system prospect in future. Well, as the fourth speaker, I would like to give a brief presentation with the title Discover Future Prospect of Indonesia Criminal Law Reform, questioning other criminal law existence, material and formal legislation, and constitutional court decision frameworks. Next slide. Based on the title, I would like to split my presentation into three main issues. First, about national legal political direction. The second is the existence of living law in criminal legal substance. And the third is the constitutional court and criminal legal substance. In the first layer, it would be discussed about first about the paradigm or orientation, the rivalry between legal unification and the legal pluralism. And the second, related with the recent globalization era or the 4.0 industrial revolution era, rivalry between complex cultural transformation with cultural gaps in national development direction. And the third, material criminal law problem and formal criminal law problems. In the second layer about existence of living law, we will to learn about first about legislature, academician, and stakeholder effort to accommodate the existence of living law or adat law into the Bill of Indonesia Criminal Code. And the second about the adat autonomy based on Van Vollenhoven argument about rechtspraak, self-destur, policy, and regulering. And the third about the constitutional court decision and the criminal legal substance problems. Next slide. Based on the three layers of main issues that I would like to present today, we can to understand that the overview of the challenges in reforming Indonesian criminal law. Based on general overview of the commitment to reform Indonesian criminal law, first, we would like to understand how about the constitutional pluralism and legal pluralism aspect. In this context, related with recognition of other criminal law in the Indonesian criminal legal system. The second, related with reform criminal legal policy paradigm within reorientation and rearrangement. And the third, related with the constitutional court decision and national statutory law perspective. Next slide. Well, the first problem is related about Indonesia Development Plan Program, Legal Development Master Plan. In this context, we can see from this PowerPoint. First, related legal political of law of Indonesia is based on Pancasila law ideas or Cipta Hukum Pancasila as the legal philosophy and legal direction. In this context, we can understood that legal political placing law as an instrument to realize national goals and ideals with final destination, national legal system that reflected national ideas. In this context, the legal substance development that related with Pancasila law ideas has three main agenda. First, related with reforming national statutory law. Second, reform colonialist inherited statutory law. And third, related with create new statutory law based on national identity, social values, and interests of Indonesia society. And we also could say about the RPJMN and also RPJMN related with this matter. Next slide. In this context, when we discuss about our RPJMN, we can see that our commitment to reform Indonesian criminal law has been underlined, started from the RPJMN 2005 until 2009. In this RPJMN, it stipulates that internalization of justice and law enforcement to create stable foundation of national legal supremacy and human rights enforcement based on Pancasila and Indonesia Constitution and create ideal national legal system. In the RPJMN 2010 until 2014, it also stipulates that increasing of legal consciousness and legal enforcement based on legal supremacy consolidation and furtherance of human rights enforcement and strengthen national legal system. And also when we see in RPJMN 2015 and 2019, we also understood that RPJMN 2015 stipulates that internalization of democracy value, tolerance, non-discriminatory, and empower decentralization and regional autonomy with shift legal consciousness and legal enforcement within maturity of national legal system to support national development. And in the current RPJMN or RPJMN 2020 and until 2024, we can understood that our RPJMN has regulated internationalization of national legal and political within democracy consolidation, legal supremacy, and human rights enforcement. In this context, Indonesia legal system shall be based on Pancasila and Indonesia Constitution. And in this context, it's supported with good governance, bureaucratic reform, and national identity. Next slide. Now we move to the next problem. It's related about adat criminal law, and I put the question in this PowerPoint. It is still excess of dying, because in this context we can see about the two main problems. The first, in the context of our legal system has recognized the existence of adat criminal law. When we research from the Article 5, Paragraph 3, the emergency law the years of 1941 concerning civil judicial system, and also Article Law 48 years 2009 concerning judicial power, and also within Article 18B, Paragraph 2, and Article 28I, Paragraph 3 of the Indonesia Constitution, adat criminal law has been recognized in the legal substance. However, when we discuss about the Indonesia Criminal Code, it is just an ideal. It becomes the guiding point to arrange adat criminal law recognition into the Bill of Indonesia Criminal Code, that placing definition of legality, formal legality, not into the material legality principle. And adopting adat criminal law, it is still questioning. Next slide. When we understand about the criminal adat law, we can compare between the RKUHP 2009, RKUHP 2014, and RKUHP 2019. And in this third RKUHP, we can understood that there are three main problems. First of all, criminal adat law existence towards the principle of legality, and the second about the recognition of criminal adat sanction application into material criminal code or law, and the third about the application of criminal adat law into criminal justice and law enforcement. In this context, when we discuss about the first context criminal adat law existent towards the principle of legality, there is the rivalry between the material legality principle and the formal legality principle. And the second, when we see in the second layer, the recognition of criminal adat sanction application into material criminal code of law, we also see about the other sanction belongs to subsidiary or complementary sanction. And in this context, towards adat crimes that needed the adat recovery. And the third point in this comparison, the application of criminal adat law into criminal justice and law enforcement, it is related with how to judges is given the authority to determine the fulfillment of local adat obligation and obligation according to the living law. And in this context, it can be considered comparable to fines category 1 or category 2 based on the RKUHP 2009, RKUHP 2014, and RKUHP 2019. And the last problem that we can also learn in the next slide is Indonesia Criminal Procedural Code or KUHP and the Constitutional Court decision. And in this context, I would like to conclude that there are 9 Constitutional Court decisions that we can learn, and also it has impacted to the Indonesia Criminal Procedural Code. And finally, I would like to conclude about this presentation today. First of all, the Indonesia criminal law reform, including the effort to reinventing national criminal law within reorientation and reform based on socio-political, socio-philosophical, and socio-cultural values. In this context, it also shall reflect different social, cultural, and legal needs for all stakeholder parties, while the national legal, political, shift legal unification within local genius, stressing 5 principles of Pancasila and implementing national identity. In the second layer, we can understand that the future prospect of Indonesian criminal code shall to accommodate other criminal law into the new bill, and also in this context to reintroduce the new paradigm for judges and law enforcers in implementing other criminal law into national law enforcement within local genius, and also Pancasila framework to deliver criminal code reform within cultural, religious, balance of tangible and intangible values, and also the ability to select other criminal law that still exists and in line with international and national criminal policy reform standard. And the last conclusion, it's related with the Indonesia Criminal Procedural Code or KUHP shall to reoriented and reformulated within constitutional court decision that in line with national values, national identity, and spirit of criminal justice system reform. Well, last but not least, I wish my presentation would be useful too, and I'm so pleased that today my presentation would be the part to bring our ideas and also bring Indonesia criminal reform in future. And finally, it also shift the criminal law reform based on our identity, our own values, the legal justice, the legal certainty, and also dignified constitutionalism, rule of law, and human rights value. Finally, thank you for your attention.
Presentation, Mr. Bagus Hermanto. So, ladies and gentlemen, we end the presentation session. So, one more time, please give applause to all speakers for today's seminar. So, ladies and gentlemen, now we will continue to the Q&A session, the question and answer session. So, this session will invite 2 questioners from offline participant and 2 questioners from online participant. So to all participants, please. And I would like to tell you that if you want to ask a question, please, before you ask, raise your hand and tell your name, from what institution do you come from, and also to whom your question directed. Thank you. Okay, I will pick one from my left side, and okay, 2 from my left side. Yes. Please, staff, could you give the microphone to the questioner, please? Yeah.
Okay. Thank you for the opportunity. I'm Gede Wahyu Prasetya. I attend Udayana University Masters of Law program, and I have several questions for perhaps for all of the speakers regarding the criminal law reform in Indonesia. So we have seen the discourse that Mr. Tim Lindsay provided the discourse towards integralism, which made our law being, let's say, easily corrupted, and where we understand that the state and society are the same, no check and balances, such as integralism. So, and we have seen that in here, other speakers such as Mr. Ida Bagus Redharma and Mr. Lukas Banu, also Mr. Bagus Hermanto, have provided us with insights on how to tackle those challenges in reforming Indonesian criminal law. So, I'm interested in integralism as an legal ideology, quote unquote. So, the way I heard it, it provides me an image of centralism, such as what Suharto did back in the New Order. And as such, we will of course need a method or a way of thought that is not attached into centralism, like maybe decentralization, but that's probably not enough. Maybe something like a federation, but that's not provided in our constitution. But well, I was expecting for a proposal that provides us a more sporadic and a more enterprising solution into tackling those challenges in reforming Indonesian criminal law. So, heading into my question, if one root of the Indonesian challenge in criminal law reform came from such an idea of integralism, what would be the antithesis of such an idea? So, to reiterate, in my view, a centralized effort of criminal law reform, such as the one proposed by Bagus Hermanto, will not suffice, except when there are wider and plenty of opportunities for the whole civil society to participate in reforming the Indonesian criminal law. So I hope we do not forget that there are participation aspects in reforming Indonesian law, in this regard, the Indonesian criminal law. Thank you for the opportunity.
So thank you for the question. So your question will direct it to all speakers.
Yes, thank you.
Okay, the next questioner, please.
Thank you, Mr. Udayana Jaya, as a moderator. Give me a time. I would like to asking to Mr. Dr. Haji Surya Dharma Jaya, but first I would like to introduce myself. My name is Wahyu, Made Wahyu. I'm from Udayana University. For this time, I would like to asking how to applicating harmonization between fairness and certainty law, because as we know together, so many theories about fairness, but always has different feels about fairness between victims and perpetrator. Which theory can be used for that problem? That's my first question. And the second question to Mr. Lukas Banu. As a practitioner, I would like to asking you about how to cancel the nominee agreement with the parties if in the future there is distrust with the local parties. I think that's all. Thank you very much.
Thank you for your question. So I will invite online participants to ask the question. So today we have Dr. Idewa Gede Palguna SH Enghong. He is a former judge of Republic Indonesia, Constitutional Court of the Republic Indonesia, who will ask a question, and I hope Dr. Idewa Gede Palguna also gives some insight or some inflection to our participant today. So to Dr. Idewa Gede Palguna, time is yours.
Thank you, moderator, and beautiful participant of this international seminar. And I would like to thank Professor Lindsay. We meet again here. I think at around at around 2 years ago, we met at the University of Indonesia with Professor Simon Watt, if I'm not mistaken. So should there is no COVID-19, we would have been met in Melbourne or in Sydney for an international seminar that is cancelled for the time being. Thank you, Professor Lindsay, for being with us today. I would like to ask for my colleague, Dr. Ida Bagus Surya Dharmajaya and Pak Lukas Banu. It is especially for Pak Lukas Banu. It is important. It is interesting when you mention Susan George with your presentation, because I know quite well that Susan George is not in favor with globalization. Instead, she is the stance, or maybe the strongest opposition of the idea of globalization. And then he criticized the three main fundamental principles of globalization, as you mentioned. This is free trade, free goods and services, and free circulation of capital, and the freedom of investment, which he said it is what is the fundamental of the ideology of the so-called neoliberalism. So I think it is worth noticing here when Susan George compared the three fundamentals of globalization as a betrayal to the welfare state idea. But instead, if I'm not mistaken, Pak Banu, Pak Lukas Banu, you mentioned in your presentation, forgive me if there is a mistake in my perception. You mentioned Susan George as your what is the kind of background to your presentation, which is instead Susan George is the strongest opposition, one of the strongest opposition to the principles of globalization. So I would like to ask you your explanation about this the opposing idea. And to my colleague, Ida Bagus Surya Dharmajaya, I would like to ask you a question. What do you think about the next trajectory of our criminal justice system? If we stay with our idea to absorb the adat law criminal value or criminal law practice in the archipelago, in the entire archipelago of Indonesia, because I think there is an opposing idea, especially when we are talking about the principle of certainty. While the so-called modern criminal law emphasizes its idea with the principle of the nullum delictum nulla puna sine praevia lega punali, and on the other hand, the adat law principle emphasizes the principle of fairness, asas kepatutan. So, what do you think? Can we absorb these two opposing ideas in one single policy of the development of our criminal justice system? Thank you very much, moderator.
Thank you so much, Bapak Dr. Idil Gedung. So we will invite another one questioner from online. So you can ask in Bahasa before, because I think Professor Tim Lindsay also understand about Bahasa Indonesia. So if you ask with Bahasa, you can do it chat room, and Ibu Ayu or Bapak Sigit will help you to translate into English. So is there any online questioner who will ask a question? So I will invite another one questioner from offline from this room. So please raise your hand if you have any question. Okay. Okay, on the right side. Yes, Ibu.
Thank you for moderator to give me a chance to give some question. So I'm Irma. I'm from the master degree student. So I'm having two questions. The first one for Mr. Lucas. Such a great presentation. So I want to ask you regarding the criminal side in the investment. As you know, because of this kind of capital regulation and then the land property 5 billion. So what do you think the best solution to avoid the legal embezzlement of investment activity? So what will be the best solution related with the criminal code arrangement? And the second question I want to ask to Mr. Bagus regarding the living law. As you know that we have many living adat law in Indonesia, so it's I think it's difficult to make it like a unity. So what do you think regarding the living adat law related with the criminal code draft at the moment? Is already accommodate the living adat law, or is it not yet accommodate? Thank you.
So thank you for your question. So it's time for the speaker to answer the question. So I will give the first chance to Honorable Professor Tim Lindsay to answer the question from the questioner. To Professor Tim Lindsay, may you proceed.
Thank you very much for those questions. And just let me begin by offering my very warm greeting to Pak Palguna, who was a wonderful judge of the Mahkamah Konstitusi. I think Indonesia misses him in that role. So good to see you again, Pak. I look forward to seeing you in Bali and having a lot of arguments about law with you. I was asked a question about integralism, and one of the aspects of it is the antithesis of integralism. And that's a very easy question to answer. It's liberal democracy. Liberal democracy is the precise opposite of integralism. And if you look at the debates in 1945 about the Constitution and the Dasar Negara at the time, there were a range of different parties who were arguing. There were supporters of liberal democracy, there were supporters of an Islamic state, there were supporters of a socialist or communist state, but there were also the integralists as well. The debates between them were very clear. It was very clear in those debates that liberal democracy and integralism were the exact opposites, and a choice had to be made. So the choice, and this is well known, these are not new, but the vote was in favour of a democratic system, a Rechtsstaat, not a Rechtsstaat, but the job given of drafting to the person who was the strongest supporter of integralism. So the nominally democratic constitution that was created was really fundamentally integralist in nature, because it did what integralism does, which is to give huge authority to the leader of the state and minimise checks and balances and rights, which is exactly sort of liberal democracy, which wants diversified authority across institutions with none having a monopoly and with checks and balances. In particular, rights. If you look at the first draft of the 1945 Constitution, it mentions rights but gives authority to the DPR. It doesn't actually guarantee or confer any rights at all. It gives no rights. It simply sets up a mechanism which rights can be dealt with later. So that's exactly integralism. It mentions rights but doesn't confer or guarantee any of them. So the exact opposite was liberal democracy, and the Indonesian political pendulum swings backwards and forwards historically between integralism and attempts at liberal democracy. We've seen that twice in the 50s and since 1998. And many scholars of Indonesia now argue that there is a democratic system. We will see whether that proves, but there are lots of indications of it. I talked about the attack on the KPK as one of the most worrying developments in criminal law in Indonesia, and many observers talk about that as an indication of a decline in liberal democratic checks and balances. And we have to argue with that, I think. The second part of the question was about centralised reform of criminal law. And I take by centralised, you mean top-down, the government driving reform, and whether that can actually work. And I think it's pretty clear that when you are embarking on law reform of a fundamental statute that has wide universal almost implications, that top-down centralised reform is not effective. And that's not, I'm not talking here just about Indonesia, I'm talking about the worldwide experience of reform. We have to remember that KUHP and KUHP affect all Indonesians in one way or another, because they talk about regulating the relationship between state and society. Now, if you have a top-down process, then there are two difficulties. First of all, you have limited in policy formation, which will always mean that policy will be weaker than if you had wide consensus. Because criminal law is extremely complex, and you need to hear the positions of the wide range of parties who are affected by it. And civil society provides a channel for collecting and communicating the views of a very wide range of stakeholders. And unless civil society is very closely involved in the policy formation through consultation in particular, and through a wide public discourse that involves the media and all other different stakeholders in criminal law reform, then you're going to have weaker policy than if you did have that engagement. So centralised top-down reform usually results in poor policy. The second point is that because KUHP and KUHP affect so many people in so many different ways, that means that almost every provision of reform is going to be contested by different parties. And we know that because every time we attempt to reform these two codes, there is huge controversy, because there is no wide consensus on so many of the provisions, whether they're about sexuality, whether they're about religion, whether they are about pra-peradilan, whether they are about the death penalty, all these sorts of areas. There is a lack of consensus about how they are to be applied. And that is also a product of an over-centralised process. If you have wider consultation and discussion and wide discourse on it that is actually part of the process of the formation of policy, then you are much more likely to be able to build public consensus in favour of controversial provisions, or that those protests, those controversies will be channeled to rectify the provisions. As it stands, because it's been such a top-down process in many ways, every time the code comes out, it sparks huge controversy. The biggest demonstrations since jatuhnya Soeharto. That's not an accident. So the process, as you say, is part of the problem. And I do link the way in which governments deal with the criminal codes. That tradition of integralism underlies much of the legal culture of Indonesia. Not all of it, but it is a line that runs through from the historical past, and which undermines repeatedly attempts at reform, particularly in this area, because criminal code affects wealth, freedom, social structures, power. And so if you're going to see integralism emerging anywhere, it's going to be in political laws and criminal laws. And that's what happens. So I'll finish off my comments by saying one of the strange things is that if you want to depoliticize the reform process for criminal law, you have to engage in wide political consultation. So in other words, to have the controversies and the protests through a wide consultation where a large range of parties are listened to and have input, than to have your political process emerging after you have a draft. And then you have a very explosive situation. So again, lack of consultation, a less open process is part of the problem, and why reform has never able to work in this area. Thank you.
Thank you, Professor. So I will give the second chance to answer the question from the questioner to Bapak Lucas Banu. So Bapak Lucas Banu, may you proceed.
Yeah, thank you for the questions. The first, I want to thank you for Bapak Palguna. He's one of my idol lecturer in Faculty of Law as well. The last time we met in Garuda Lounge at Airport Ngurah Rai on the way we going to Jakarta. Thank you, Pak. I just want to make a clarifications in globalizations. That's why in the beginning I said that Susan George is one of the person who not agree with the globalization. Actually, I'm using this book, Pak Palguna. This is your book. The 4th chapter is my favorite one. I read it many times. Repeat again about globalization. Thank you. That's why I'm looking for the another literature about Susan George. She is one strong lady who sound about the justice, about social, pro-social, and she give comments about the globalizations group. She said there are 3 fundamentals. I'm not saying she agree with these 3 fundamentals. She just gave comments about the group who support the globalization. 3 fundamentals: free trade of goods and service, capital circulation, the freedom of investment. This in the page 84 in this book. I encourage for everyone in here to buy this book. This interesting. Thank you, Pak Palguna.
Thank you.
Yeah. The first questions, I think I will give opportunity to the other speaker to answer. I want to answer the second questions about the how to cancel nominee agreement, if I'm not wrong. We know that Pacta Sunt Servanda, the agreement is the act for the parties who made it. So if you want to cancel the agreements, must be both parties to cancel this one. But we need to understand there is a potential criminal law in this activity, in the nominee agreement. That's why in the last slide of my presentations, I give the recommendations to all the institutions. There must be working together, commitment together to against the wrong practical about legal investment in nominee agreement. Last time, 2 weeks ago, I met with one of my friends in the immigration officer. He said that there's a program from them to working together with all institutions to looking for all the nominee. So this is a good idea for them. So that's why it's very important to tax department, prosecutors, police, and all institutions related to working together to clean or to bring the legal certainty in this area about legal nominee. And the last questions about the best solutions, I think I already answered in the previous explanation. The first one, we need to understand about the preventive activity and repressive. The preventive one, we have to shout time to time and also do the socializations about what should be done in this activity, I mean in the investment activity. Not only for the lawyers, but also for all the people, the society, community, that they cannot just give themselves to be the nominee, because there's a legal consequences for that. There's a criminal law potential on it. And for the parties, institutions who hold the authority, they have to be 100% commitment to do the legal protection, to the law enforcement about this criminal case. Until now, we not hear so much, especially in Bali, about the case that already punished by the court regarding with the nominee case. Is a criminal or not? I think for the future, we need one of the cases so that can be the jurisprudence in the future that can be used to bring legal certainty in this case. Just give the punishment or like a fine or something can bring the like the lesson for everyone. And for the last one, for the foreigners, if the foreigners, the candidate of investor come to me, I always explain, sir, you have to do this way, do the right things. If you want to do like a zigzag, you know, like a break the regulation, blah blah, I always say to them, it's better for you to find another lawyer. I don't want to follow your wants. I just want to follow the regulations. So there's a commitment also for all the practitioners to be committed to not because of the money, because we think that we will fight for anyone who pay us. No, we have to fight for the justice. Thank you.
Thank you, Bapak Lukas Wanu. So I will give the next chance to Mr. Bagus Hermanto to answer the question. So to Mr. Bagus Hermanto, may you proceed.
Thank you for the moderators. In this context, I would like to simplify the two questions for myself that delivered by my colleagues. This main point problem is related with the existence of living law or the adat law in our criminal code in the future. I believe that plurality of our nation would be recognized into our criminal code. However, the rivalry between legal pluralism and legal unification are still discussed until nowadays. In this context, I would like to stressing first related with the main argument why it could be implemented in the future. It related with first, the post-independence national legislative policies have partially encouraged efforts to explore, study, and apply the values and sense of justice that exist in society. And the second, there are several scientific resolutions on consensus in a number of national seminars. First, in the National Seminars Law in 1973, that stressing and encourage the application of living law or adat law and shall not hinder the formulation of the people aspiration to and accommodate religious elements and adat law that are woven into the new criminal code. In this context, the report of the fourth National Law Seminar in 1979 encouraged national legal systems that it is in line with the needs and legal awareness of the Indonesian people, as far as possible, strive to be written in the legal unification, but does not rule out the unwritten existence as a part of national law. And in the 1980 National Criminal Law Reform Symposium report, it encouraged that in-depth research and study of other and religious criminal law that exists in society. And the third argument is related with sociological foundation that starts from the family law culture, which produced the concept family legalism, and also the concept of rule of justice and moral. And the fourth, related with the basis of international consensus in Article 15 ICCPR, there are two sources to state that a crime is punishable, namely based on law or positive law, and based on general legal principle that recognized by the public. In the second argument, it related with the five main problematic that arises of a strengthening effort to stipulate and apply other criminal law in Indonesia. In this context, I would like to stressing there are five main problems. First, related with the legislature and state fail to draft regulation instrument in form of national statutory law that reflecting direction and ideas of national legal development. And in this context, to translate local genius and Pancasila values, including in the criminal court reform. In this matter, that also related with the gap between paradigm and concrete effort that facing to drafting and enacting new Indonesia criminal code that in line with national legal development direction. In the second term, it related with the rivalry between the state law and the local law that resulting clash or gap between state law and local law. Theoretically, the competition between state law and local law, two dominating legal systems, shift final result with the state law domination and marginalization of local law, while it more effective and functional than state law. In the third term, related with the discussion and arrangement effort to create national criminal code reform, still does not discuss it and shift participation of social, culture, or political scientists or academicians, especially any other parties, including other communities that exist in Indonesia, to synchronize and create strong foundation of new criminal code that reflect Indonesian national aspiration. In the fourth term, it related with the principle of legality has been a main element in the legal certainty related with existence of crimes and crime sanction that shall interpreted within neoclassical paradigm based on Dader's structured concept. The principle of legality still cannot interpreted contemporarily in Indonesia criminal code. And the fifth term is related with there is main problem related with the difficulty to reach common ground and differences between other criminal law and the principle of legality. In this context, the other criminal law is based on philosophy of harmony and communal morality, while the principle of legality has a legal definition of crimes. Punishment should be fit to the crime and the doctrine of free will, no empirical research and definite sentence. Then in this context, there are 8 basic terms or basic things that we need to understand to evaluate the characteristic of other criminal law that would be regulated in the new Indonesia criminal code. First, related with there is non-dichotomy between criminal law and private law based on ultima ratio principle or principle of restraint that affirming mutually supporting sanction and compensation in criminal law, administrative criminal law, and disciplinary action. Second, the prominence of communal morality is balanced with institutional morality, civil morality. The third, related with the other criminal law, is complementary to the principle of prior existent regul. The fourth, the settlement through conciliation in individual offense that do not involve an association in other law, so that is limited to minor crimes, and in this context can be linked to alternative sanctions. The fifth, the problem of the ability to be responsible for a madman or children in some other crimes cannot be accepted on the basis of doctrine that there are staff rank. In the sixth term, it related with in certain conditions that criminal law individualized based on social stratification, and in this context, it is necessary to develop the principle of equality before the law on universal and objective reasons. The seventh, in under criminal law, the vigilant action in certain matters can be justified. And the last term, the punishment guidelines are often oriented to the principle of that strafrecht, so that the losses of the victims are considered to determine the severity of the crimes. Well, in this context, this is about the main stressing about the two questions from my colleagues. That's all. Thank you.
Thank you, Mr. Bagus Hermanto. So I saw on the monitor that Dr. Idewo Gede Palguna raised his hand, so maybe Dr. Dewa Palguna will give some insight or interaction or give some opinion.
No, I think that's the real problem. Thank you, moderator. I think that's what is the essence of the problem when we are talking about the development of our criminal justice system here in Indonesia. Because if we want to absorb there's so many traditional practice that we call added criminal law. That's the point of my question shall be, or as I mentioned earlier, that how we could accommodate the very on the one hand the very practice of added criminal law across the archipelago, and the second one, that if we stay with the principle, or if we strongly hold the principles of fairness as the basic principle of adat law, it means that we should set aside the principle, the so-called principle nullum delictum nulla punat sine pia lege punari. That is what I would like to say. And I think it is still since the effort of once, I think Professor Van Vollenhoven, if I'm not mistaken, have tried to make an effort. What he said, the satu hukum adat untuk Indonesia, I mean, which is include the criminal law with it inside the idea, but as we know, it failed. What about now? That is the main question of mine. Thank you very much.
Thank you, Bapak Dr. Idewo Gede Palguna. So, ladies and gentlemen, I would like to inform you that Professor Tim Lindsay AO will have another activity in 11:30. So before he leave this room, so I would like to give a big applause to Professor Tim Lindsay for your presentation, for your opinion, ideas, and also for your talk. Thank you so much, Professor. So we'll continue to question. Oh, sorry. So I have to give a chance to Dr. Idabel Surya Darmajaya or Ibu Igusti Agung Ayudi Widya Astuti to answer the question from the questioner. So time is yours.
Okay, thank you, moderator, for the chance for me. Maybe I will to generalize all the question from Bapak Wahyu and also from the students about the movement or the implications to move on to the criminal law in the future. So the main challenge in reforming the criminal law is about our perspective. Yeah. So the paradigma, the last paradigma and perspective is still dominate us. So all of us is still difficult to achieve this new kind of law. So at first we need to understand the idea behind the law. That is the first movement, I think. So, RUU KUHP is trying to harmonize what they want to harmonize. Many things such as like fairness and legal certainty, and then between humanistic and legality principle, between culpability and legality principle, and many things they need to harmonize. And this is very difficult for us to understand if we don't understand about the ideas behind this RUU KUHP. So I would like to say that the first movement for how to achieve or antithesis for this kind of new law is change our paradigm first, change our perspective. We cannot stay in the last perspective, which is still positivistic, legalistic, individualistic, which is contained in the RUU KUHP, I mean in KUHP. We have to move from that. So that is the main challenge for me. If we are not going to change the paradigm, the perspective of law, our criminal law, which is it's very difficult for us to understanding the RUU KUHP. That is the first. And maybe Pak Surya will adding another opinion. And then for Bapak Dr. Palguna, actually we also found and still debating about the existence of the living law in RUU KUHP, not only the inside, not only the outside of the academician in this law. We in the criminal law is still debating about this and how to actualize, how to mix it with the positive law or the written law in the future. So based on what we learned in the criminal law reform, like I said before, we must understand that RUU KUHP ideas is keseimbangan monodualistik. This is the important thing we have to understand in my opinion. And this is keseimbangan monodualistis is try to harmonize the formal and informal thing which is restricted by Pancasila, Undang-Undang Dasar 1945, and international values and principles in the global community. So doing a balancing, we understanding that doing a balancing is not easy. And about the legal certainty, it will be harmonized with fairness and humanism, so we will get the legal certainty will stand together with benefits and fairness for all the parties, not only for individual, not only for victims or not only for the perpetrators, but for all of us, for the perpetrator, for the victim, and also for the community. And to do harmonization, actually about the living law, legal certainty must see in the wider side. We cannot see the law only as in the book, but also we need to see the law in the unwritten law or the living law. So in the future, this is of course going to be the job of the judge, because the judge will have a good, will have a very hard work in the future because they need to see these two aspects before deciding. So they need to see the law in the book, and then they also have to see the unwritten law. That's why RUU KUHP regulate a sentencing purposes and guideline for judges in the future, so they still have their independency to make decision. If they thought that no need the interference of the living values, they can use only the live law, the written law, what applicable law in the RUU KUHP. That is my opinion, and I think the existence of the living values also must be not only for adat criminal laws or only for the adat laws, but also for the values, other values like religion and other kinds of values which is living in Indonesian people. So we have to understand that if we are talking about RUU KUHP, we are going talking about the Indonesian values, which is not only a written law but also unwritten law. So RUU KUHP, in principle RUU KUHP still hold the legality principle, and the living law only gonna be balancing in the future. Like I said before, if the judge think they don't need the interference of the living law, they can use only the written law. But if they see or they feel that the case they face it, there is a need of the interference of the living law, so they have to think, they have to consider it, they have to see the objectives about the living laws. I think that is my opinion. So this is a very hard, for me this is a very hard ways, this is a very hard perspective to change our paradigm. Maybe Bapak Surya will adding some opinion.
Thank you to Ms. Dika Widya Astuti. Two questions for our is one from Mr. Wahyu and one from Mr. Paul Muna. For Mr. Wahyu, in my opinion about your question, how criminal law in the future not just give attention to the perpetrator but give attention to the victim too. As we know, the development of the criminal law development come from classical school, modern school, and neoclassical school. Every school gives attention to a different focus. Like a classical school focus on the protection of society, and the modern school focus on criminal, the perpetrator, and two schools make one more is a neoclassical school. Give attention to not just to society, but to the perpetrator too. But the new era, as we know, victim is the people who are very suffers and harm in the criminal act, must be protected by the law. And we know, in the protection of victim, three things must we look is administrative service, how criminal process is give attention to the victim, restitution and compensation. And in this era, our criminal law try to give the victim of protection with the Undang-Undang Perlindungan Saksi dan Korban. And in the RUU KUHP, we have one punishment. Is restitution. I think in the future our criminal will give attention to the victim too, not just for the perpetrator. And to Mr. Paguna, the certainty is the most important to criminal law, because the effect of sanction in criminal law is reduce the human right very hard. Yeah. Therefore, legality principle is very important to reduce the violation of human rights. That's why in criminal law we have something we must attention, like lex serta, lex stricta, and lex scripta. And what we give living law place in our criminal law in the future, we know the living law is will not give us certainty, but we know the goal of the law not just for certainty, but justice to all fairness. Yeah, that's why the living law must exist in our criminal law. Mr. Bardanawa, according to Mr. Bardanawa, we not just our criminal law in the future, not just to see to formal legality, but immaterial legality too. Yeah. Certainty not just for the formal regulation, but to informal regulation like the living law. Because the living law can give description of our law exactly. Thank you.
So thank you for the answer, Bapak Ide Bagus Surya Dapojaya. So I think we have to, how to say it? So we need all speakers to deliver their closing statement because we still have another 10 minutes. So I will give the first chance to Bapak Lucas Banu to deliver your closing statement before we end this seminar, and then continue to Bagus Hermanto, and also either Bapak Dr. Ida Bagus Suryo or Ibu Gusti Agung Ayudika Widyastuti. So to Bapak Mr. Lucas Banu, kindly proceed.
Thank you. To close my presentations, I think we are not talking about the substance of the subject, but I would like to thank you for everything that already given, especially to me, from the Faculty of Law, from the Dean of the lectures. I can be something like this because of you. And I always remember every time in the S1 or S2, in the graduations, the Dean always remind me to bring or to be the impactful in the system of law in Indonesia. Especially we as a lawyer, there are so many challenges, but we always remember to keep, to hold the name of Faculty of Law of Udayana University to be bigger, famous, and be accountable. And always asking your support, your advice. Like I said in my declarations before I did the presentations, please advise me, because we are a family. Thank you.
Thank you, Bapak Lukas Banu, for your closing remarks, and I will give the chance to Bagus Hermanto to deliver your closing statement.
Well, thank you for this chance. Today I would like to express my gratitude, firstly to Professor Spasti and also Prof. Johannes Uskunan and also the organized committee at Master in Law program. And also I would like to express my condolence, about this moment is very interesting for me, and also this moment is very useful not only for myself but also for all of participants to discuss more about how to rearrange about our law, especially to reforming Indonesia criminal law in this context. Well, thank you for this time and this chance. Thank you.
Thank you so much for your closing statement, Mr. Bagus Hermanto. Now it's time for Ibu Dike to deliver your presentation. To deliver your closing statement, please.
Thank you, Bapak Moderator. Well, my closing statement today is first we have to understand that RUU KUHP reform based on the ideas of harmony between the interests of perpetrators and the community or victims, harmony between legality principle, culpabilities, and humanism and ethics. This idea raised a new perspective in sentencing, for instance, individualization and sentencing modification. Challenges will always be in reforming, and challenge is going to be a mirror to an alteration. And every one of us must consider it as an introspection to find a good law that appropriates with the Indonesian values and will create a just and certain Indonesian criminal law. RUU KUHP tried to harmonize the written law and unwritten law, the formal and informal, the certainty and humanism. And all these harmonization are not easy to understanding. We will fight with the applicable laws, with the perspective and paradigm, with the law enforcement behavior. And for us, this is actually the challenge that we need to reform as soon as possible if we understand the Indonesian need to have their own law, their own criminal law, not an adapted law, which is based in other values. So this is our closing statement for today's, and thank you. I would like to say thanks to the program Magister Ilmu Hukum for the chance for me and Bapak Dr. Ida Bagus Surya to sit here as speakers, and we hope that what we have delivered to you will have benefits, and we will try to understanding. Let's do a movement for the future, our future laws, which is criminal laws. That now soon will be legitimate as soon as possible. So we have from this time, we hope that everyone's participant here would like to try to change their perspective, not stay in the old perspective that which is deliver more perspective about legalistic. I think that is my closing opinion. Thank you, Bapak Yuda, and also other speakers.
So, ladies and gentlemen, give a big applause to all speakers today. Ladies and gentlemen, we are nearly close to the end of our seminar. So before we end, I will make a short conclusion for today's seminar according to our discussion. So the first is the obstacle to criminal law reform in Indonesia for decades is because in Indonesia criminal laws has played a significant part in important political events, and politics has played a notable part in criminal law. The second is criminal law reform presents challenges that open opportunities for criminal law regulation outside the criminal code, but on the other hand, some criminal acts that have occurred outside the criminal code are forced to enter with imperfect adoptions. This creates ambiguity as well as conflict between the draft bill of criminal code, RUU KUHP, and legal instruments that contain criminal provision outside the criminal code. So the third conclusion is the reform of criminal law leads to the politics of criminal law, in which it means how to make and formulate a better criminal laws and regulation in accordance with the objective to be achieved. Or in other words, the politics of criminal law is basically a policy line to determine first how far the applicable criminal law provision need to be changed and updated, especially in facing globalization. Two, what can be done to prevent crime such as customary crime and also crime in investment activity. And the third is the manner in which the investigation, prosecution, trial, and execution of a crime must be carried out. So ladies and gentlemen, I would like to say thank you so much to all speakers here and also to all professors who attend this seminar, Professor Supasti Darmawan, Professor Yohanes Usmuda, and also Professor Madi Subawa. And also thank you to all participants for your active participations. And I hope this seminar will give a new viewpoint for our future for Indonesia criminal law. So, ladies and gentlemen, I will end this seminar with Om Santi, 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 Om. Thank you so much and have a good day.
Thank you. Thank you very much for our moderator. So, because our moderator asked us to give big applause to all the speakers, I would like to invite you also to give a big applause for our moderators who lead this seminar today. So, thank you very much once again for Mr. Dananjaya and also all the honorable speakers. Would you like to come forward? I would like to invite you to deliver to receive the certificate that will be delivered by the coordinator of Master of Law program. So I kindly invite Dr. Grimade Sordana to deliver the certificate for the moderator and also the participants. And after that, we will continue with the photo sessions again. We love to take pictures, doesn't we? So, don't we? So after that, the photo session that I will also invite Professor Subawa, Professor Supasti, and also Professor Usfunan to join the photo session. So, to the moderator and speaker, would you please to come forward? Thank you. We kindly invite for the photo sessions, Professor Darmawan, Professor Usfunan, and Professor Subawa. Thank you very much. Excellencies, distinguished guests, participants, ladies and gentlemen, we are entering the end of the seminar today. We already had a fruitful and warm discussions during the seminar. On behalf of the committee, I would like to say thank you very much for your attentions during the seminar, and we apologize for all the inconvenience during the seminar. We will close with Parama Santi. Om Santi 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 Om. Terima kasih banyak untuk para peserta dan para undangan yang berkenan meluangkan waktu. Untuk sertifikat bagi peserta offline bisa langsung diterima di meja registrasi, sedangkan bagi peserta online tentunya langsung dapat diunduh. Sepertinya linknya sudah dibagikan di chat box. Sekali lagi kami persilahkan bagi peserta offline untuk mengambil sertifikat di meja registrasi dan bagi para peserta online untuk mengunduh sertifikat yang telah diberikan linknya di chat box. Sekian, terima kasih.